Interdisciplinary, and all we're going to do is continue with the track of breaking rule of law. And if you've seen an order of the papers, Anjali Sharma, if you see the order of the papers, we are going to break it. Right now on the list, I have Watching India's Insolvency Reforms as the first paper. But we are going to take Brian's paper first because he's got to whiz off somewhere and do something. Okay, fine. That's true. It's Vic's fault. And we have our chairperson who's already here, unlike our previous chairperson who was missing for the first 10 minutes. Rajiv, say hello to the group. Right? And he's going to be the one who is going to be moderating this entire session. You get to sit in the front. And the rules of the game, Rajiv, are like this, that the presenter gets 15 minutes, the discussant gets 10, and then after that, you can open it up to the floor, but the discretion is completely yours because every paper only gets 30 minutes.
I'm happy to be here again. For those of you that I didn't see at our speakers dinner on Sunday night, thank you for having me. I am going to present a little project that I've been working on with my colleague Randall Thomas, who I believe many of you know on the Vanderbilt Law faculty. He was here last year. And so we are working on this together. We learned that there is a new securities fraud class action in India under the Companies Act of 2013. And so we wanted to do a little paper on your new securities fraud class action and maybe give some thoughts on how it might be improved to the extent we thought that it was not an optimal design. When we decided to take on this project, we realized we didn't know very much about Indian law. And so we did what a lot of professors do when we're in a situation where we want to talk about something that we don't know anything about, and that is we hired a research assistant. We hired an Indian lawyer who was an LLM student at Vanderbilt to tell us about Indian law. And the first thing she told us about Indian law was that there were actually provisions that allowed class action lawsuits even before the Companies Act of 2013. And so we decided to do a paper about all of your Indian class actions. There are a number of different devices that allow one person or one entity to sue on behalf of lots of other people. And so what I'm going to do today is talk about what we understand is the various mechanisms that you have in your legal system to allow one person to sue on behalf of many others. And if we get anything wrong, I hope you will correct me, and so I can go back to our research assistant and yell at her. Anyway, so this is what we found in Indian law that allows one person to sue on behalf of many other, what we call the United States a class action lawsuit. So first, there is the Companies Act, as I mentioned. The Companies Act of 2013, we understand, allows 100 shareholders, or 1/10 of shareholders, or 1/10 of shareholders, or shareholders of 1/10 of share value, to sue on behalf of all the other shareholders for what we would call securities fraud, or it looks like violations of what we would say are fiduciary duties. Section 241 allows the shareholders that sue on behalf of all the others to get an injunction, and Section 245 allows damages on behalf of all the shareholders when a lawsuit is initiated by this group of 100 or 1/10 of shareholders. And that's new. That's new. But we found a bunch of other things that we understand would allow a class action lawsuit as well. So there is the Civil Procedure Code, this Order 1, Rule 8, seems to allow people, one person, to sue on behalf of other similarly situated people for anything. that you can file in the civil courts. And that's been around for a long time. It's not used very often, as we understand, but it's a possibility in your legal code. There's this Consumer Protection Act of 1986, which allows one consumer to sue on behalf of others for consumer protection violations. I believe you have to go to a special consumer court to file that action. The Competition Act of 2002, again, one person can sue on behalf of others that are injured by antitrust type violations. Again, there's a special, I understand, consumer or competition court you go to file those lawsuits. And then we also came across a procedure under the Indian Constitution that seemed to allow you to sue public officials. One person could sue a public official on behalf of the public at large. You could file a lawsuit in the Supreme Court or in the high courts using one of the writs that available to you under the Indian Constitution. And we understand that from time to time a class action type lawsuit is filed under these other provisions. Not very many of them, but they've all been used to file class action lawsuits. So there's a lot of opportunity, it seems like, in India for one person to sue on behalf of lots of other people. And so what we want to do, Randall and I, is to make some assessment of how effective these devices are or can be. Let's talk a little bit about the design of these class action provisions and whether they will be effective to enforce the law. And to do that, we are drawing upon 5 metrics that have been identified by class action scholars, comparative class action scholars, most notably Deborah Hensler at Stanford. She's identified 5 design questions for your class action that will drive how effective it will be. Now, before we get into these 5 metrics, I should say one thing, and that is these metrics are all class action specific design questions. There could be underlying reasons in your legal system why a class action will not be effective, even if you design it properly. For example, you may have really slow courts, as I understand you may very well have here in India. No perfectly designed class action is going to be very effective if it takes 20 years to get to the end of the lawsuit. So there are going to be some indigenous properties to any legal system that will obviously affect how robust a class action device will be. What we're going to talk about is the class action specific provisions and whether they're designed well here in India for maximum potential enforcement of the law. So these are the 5 things that Deborah Hensler says a nation should be concerned about when they're thinking about how effective their class action is. Scope. Can you bring a class action for lots and lots of different violations of the law, or are you limited in what kind of violations you can bring? In the United States, our class action is what we call trans-substantive. No matter what the substantive law is, consumer, antitrust, labor, employment, you can bring a class action lawsuit. Other countries limit their class actions to only certain types of violations of the law. The more scope, the more effective your device will be. Standing. Who can initiate the class action lawsuit? Randall and I think the most effective class action lawsuits can be initiated by private individuals, not government and not non-government organizations. In many countries, only non-government organizations or the government can bring an action on behalf of other people. But in the United States, in Canada, in Australia, any injured person can bring a class action on behalf of all the other injured people. And we think that private enforcement is much more effective than government or NGO enforcement will be. And there's a lot of reasons for that. One reason is the government is often captured by the various industries it's supposed to be enforcing the law against. Another reason for that is the private sector tends to have a lot better resources than the government does to initiate lawsuits. So that's another question to keep in mind. Membership. Who is included in the class action once it is initiated? So some countries, everyone is included, period, end of story. In other countries, everyone's included unless those people choose to opt out. And then in some other countries, no one is included unless they choose to opt in. The countries that rely on opt-in, and they are very numerous, we think those class actions are not very effective compared to countries that rely on opt-out or mandatory membership because inertia. It takes work to opt in or opt out of a class action, and people are not going to go through the trouble of opting in or opting out. So wherever the default rule is, people tend to stay there. And so class actions that are opt-out or are mandatory are more effective than class actions that are opt-in. Remedies. What relief can you get through the class action device? Can you get injunctive relief? Can you get damages? Is the class action flexible and allows you to get either one, whatever is most appropriate in your situation? The most effective class actions are flexible, allowing damages or injunctive relief as the case demands. Financing. How are class action lawsuits financed? In the United States, we have contingency fees. Lawyers invest in the class action and get a percentage of the recovery. Other countries, not so much the United States, other countries have third-party investment, third-party litigation finance. Banks invest in class action lawsuits and they get a percentage of any recovery. Other countries like Canada rely on government subsidies. They give money to the lawyers to say, go ahead and file a class action lawsuit. You apply to the government, and they say, okay, your class action sounds good. We'll give you a public subsidy for your class action. Other countries, a lot of countries, use loser pays. They say, bring a class action. If you win, you'll get your fees. So there's a variety of mechanisms to finance. Randall and I think the most effective financing mechanisms are lawyer or third-party investment mechanisms like contingency fees or third-party litigation finance. So those are the 5 things to keep in mind, we think, when designing a good class action procedure. Now let's talk about how India looks on these 5 metrics. Okay, let's talk about scope. We think, from what we can tell from your legal provisions, that the scope is very good here in India. The Companies Act allows most securities violations to be brought as a class action. The Consumer Protection Act allows consumer violations. The Competition Act allows antitrust violations. The Articles of the Constitution seem to allow public interest lawsuits against government officials, and the Civil Procedure Code seems to pick up everything else. And so it looks to us like most violations of the law could, in theory, be brought as a class action under your various provisions. Standing. This also looks good as far as we can tell. Most of these provisions allow anyone, a private party, a non-government organization, like a public interest organization, or perhaps even the government, to initiate the various lawsuits that I discussed on the previous slide. And again, the most important here is private individuals. As far as we can tell, private individuals are allowed to represent others under all of the class action provisions that I mentioned. Membership. So here we had trouble really figuring out what the various devices required. The Companies Act, Section 245, is explicitly opt-out. That's good. Shareholders are included unless they affirmatively opt out. We really couldn't tell what the other legal provisions for class actions required in terms of membership. Again, there haven't been a lot of class actions filed under these provisions, and so it's hard for us to figure out in the United States what exactly was required. If you have any information on that, I'd love to hear it. Remedies. So it looked to us like the class action could only get injunctive relief under the Civil Procedure Code. That's unfortunate. We think, again, a maximal effective class action will allow injunctive relief or damages as the case requires. Under the Consumer Act, you can only get damages. You can't get injunctive relief. Again, we think it's preferable to allow either one as the case requires. But the other provisions seem to allow either damages or injunctions, so that's pretty good. Financing. So this is the one area where we think your class action devices really could be improved. You have a loser pays system here, as we understand, in India. That is not ideal because it puts a lot of risk on the plaintiffs that would bring a class action lawsuit. You don't allow contingency fees, as far as I understand, so you can't offload that risk to the lawyer, and the lawyer can't get a percentage of the recovery, making the risk worthwhile. And the Companies Act actually has a special provision which says if you bring a class action under the Companies Act and the judge thinks it's frivolous, then in addition to paying the defendant's fees, you can also be sanctioned on top of that. So that's another deterrent to bringing these actions. And so we think that's a fairly weak financing mechanism. There is a public subsidy provision under the Companies Act that would allow you to apply and get money to bring your securities class action. That's good, but we don't think it is as good as, again, a system that relies on contingency fees or third-party investment finance. And that's one question that I have for people here today is, our understanding is contingency fees for lawyers are not allowed here in India. We couldn't really tell whether you have any experience with third parties investing in lawsuits. A lot of countries that have loser pays like you do allow hedge funds and investment banks or other investors to buy up shares of lawsuits to help finance them. Give money up front to the lawyers and to the class members in exchange for some percentage of the eventual recovery. We couldn't tell if that's going on here, but if it is allowed here and it is going on here, then that mitigates some of our concern about the financing mechanisms here. And so just to kind of summarize where we are, what would we recommend to you if you wanted to maximize the effectiveness of the law enforcement through class action devices is to move your membership to opt out for all the other provisions that we couldn't tell if it was opt out or opt in. The Companies Act is opt out. The other ones were unclear. We think that you should allow more complete remedies for actions brought under the Civil Procedure Code and the Consumer Act, allow injunctions in addition to damages under both of those provisions. And then our main recommendation is with regard to financing. You need to find some way to allow either attorneys or third parties to invest in class action lawsuits in order to make those a really effective way to enforce the law. Thank you very much.
Thank you, Brian. May I ask Vikramaditya Khanna, is he around?
Hello, thank you.
You have 10 minutes.
Thank you so much. Hi, Brian. Thank you very much for your paper. I enjoyed reading it. I'm going to sort of contain my comments to just a couple of headings. One is on the details of the various kinds of aggregating actions that you're talking about here. And then the other is mainly to some of the conceptual points that you're raising when you're talking about Indian class actions. So on some of the details, you're right to note that India allows for a lot of different ways in which multiple parties' interest in an action can get aggregated. I would be a little hesitant to call them class actions because they don't really look like or behave like class actions. Take, for example, Order 1, Rule 8, the general the general procedure in the Civil Procedure Code. So it's an opt-in structure that has injunctions as a remedy, but the main constraint on it is the fact that courts are very reluctant to appoint someone to be the representative of a group because you need to show that your interests align with everybody in the group. That's going to make it very, very hard to get those started. An example of why it's so difficult to do those would be, for example, the Bhopal gas tragedy. They couldn't bring that as a tort class action because it wouldn't fit within Rule 1, Order 8. It wouldn't fit within some of the other things, and then the government took it over as a parent patri capacity, which is also in the background there. Another thing I might mention about the details is there's one kind of aggregating mechanism that you left off the list, which is a derivative suit. So companies in India are subject to derivative suits. You don't see too many of them, not so much because of the absence of contingency fees, I think, but more because of the fact that, again, there are procedural obstacles that are very difficult to overcome to actually bring such a suit. So you tend to see only a handful of such suits in the Indian context. On the broader sort of conceptual points, so I understand the five-factor analysis you've put up there from Deborah Hensler's work. I would be inclined to add a sixth factor at least, which is how do you deal with frivolous litigation? In the US context, there are ways in which people might think of addressing that. In India, it's much harder because since it takes so long to actually get a decision on the merits, you almost never get to a stage where someone gets penalized for bringing a frivolous suit. And as a result, a lot of the curtailment of remedies and the procedural obstacles can be viewed as an ex-ante attempt to block a lot of that frivolous litigation. So let me give you an example. So everyone knows about the delays in the Indian judicial system. Depending on what area of law you're looking at, 10, 15, however many years. So why does anybody bring suit in India? Right? So it seems like a colossal waste of time if it's going to take you 20 years to get a court decision. Typically, people are not looking to get a court decision. They're looking to get a settlement. The game is about getting an interim order as quickly as you can in your favor, thereby pushing the level of the delays onto the other side. Interim orders have a weird tendency to them, which is since they're interim, you don't really have a factual record to look at. So they're largely like throwing darts in some ways. And typically the general perception is that courts give interim orders for a variety of reasons, but one is just the face value of the attorney who's bringing the case or opposing it. None of those would get reflected in sort of the kind of factors you're mentioning, but they would become relevant if you're thinking about frivolous suits. Most of the concern and regulation that we see in the US is around that point. When you say, is someone a good representative, what you're trying to assess is, are they bringing a worthwhile suit or not? So that seems like a really important consideration to bring in. Moving a little bit further in that direction, you mentioned about the financing in India. So lawyers in India who litigate in court are not compensated the way we typically think of in the US. In the US, you're on an hourly rate, maybe some blended fee nowadays if you're being a little sophisticated, or maybe third-party financing. In India, they're paid by appearance. Now, what does that mean? That typically means that when they make an appearance on your behalf, usually more than a de minimis one, but something, they're paid per appearance. The ones who have the most face value are paid amounts that would normally make American lawyers feel jealous. Let's put it that way. It's not unheard of for the top 20 or 30 senior advocates to be charging in the range of about 15 lakh per appearance. That's 1.5 million rupees. That is a lot of money, and they do typically 3 to 4 of those, maybe more, a day in the Supreme Court. That is a very different way in which you pay for legal services. Trying to bring in a contingency fee structure there will not have much effect unless the amount of damages is tremendous, because they're making so much more through doing the appearance-based system, where often they're getting matters resolved in, shall we say, different ways than you might in the US. So I'd worry a little bit about the financing, about trying to bring over the pure third-party financing, unless you're looking at tribunals where that sort of hyperbolic charging is not really present. All right, now, one thing that's interesting is, in the US, when you're looking at aggregating mechanisms, one of the ones that tends to be perceived as working fairly well are things that are along the lines of key tam litigation. For those of you unfamiliar with it, key tam basically means that someone acts as a whistleblower and brings a lawsuit, and at one point or the other, the government has the opportunity to take it over. If they decide to take it over and they recover something, then the litigant receives some percentage of that, typically between 10 to 15%. If the government doesn't take it over, they can't actually kill it. The litigant can pursue it on their own, and if they win, then they can claim maybe 20% of it. Those are thought to be fairly good because with the government as kind of a screen in the middle, it helps in deterring or at least signaling to the courts which suits are probably not really that strong and which maybe have some merit. These can generate a lot of money. The largest one I'm aware of is one that led to a damage award of about $1.3 billion. The whistleblower recovered 15% of that. I don't know exactly what that would be. I don't care. It's above $100 million. I'd retire. So that's really a different kind of a model in some ways. And I can imagine, maybe not the government, but some kind of early screen to sort of work as a sieve to get through a lot of the frivolous stuff that might be brought could be particularly effective. Those are some early thoughts on the idea. It is interesting, some of the mechanisms you mentioned, you don't tend to see being used with a great degree of frequency in India. Part of that is just because reporting is a little off, but also because with the delays in the courts, they might find it advantageous to bring other things that might induce a quicker settlement, sometimes not exactly the thing you'd expect. The standard sort of saying is that you can scratch your ear this way or you can scratch it this way, depending on which you find to be more effective. And that can vary with the context. But overall, I'd say looking at how do you police frivolous litigation and alternatives that have early screens in the process might be effective. The early screen substitutes for the interim order structure, but without actually having to issue an interim order. Thank you.
Thank you. I'm glad we've stuck to time. I just wanted to make one observation before we open the floor to questions on this particular paper. It's just a thought about the nature of the body of law in our country. So there's a tendency to add complexity to a body of law, which then gets embedded in the system without regard to the institutional and other aspects of the ecosystem in which that law is supposed to be implemented. And there is a huge mismatch between the complexity of what's in the law versus instruments and institutions to adjudicate that. So that's just a broad thought in background. Any questions? Gentleman over there.
Great presentation by Brian and a lovely, great discussion by Vic. A lot of good points. There were 2 points I just wanted to mention. One is to underscore the point which was somewhat tangentially mentioned by Vic, which is the speed of the Indian judicial system. One of the important or very huge constraints in the Indian judicial system is the fact that cases never get decided. And even cases like the Bhopal case took God knows how many years before any kind of relief could be provided. So any kind of class action is very, very heavily constrained by that. Number 2, you mentioned the fact that injunctive relief is what is available in the case in most of the cases. Even if there are damages which can be available, the scale of damages in India have been very low, or at least that's my impression. Because the scale of damages is very low, the incentive to pursue something for years and years and years and years on end is very low. And a lot of the time, injunctive relief becomes ineffective. Injunctive relief is sort of lived its time. So, that's 2 points I wanted to make.
Can we take comments at once and then we'll be more effective? Why don't you go next? Yeah, you can speak into this.
No worries. I'll just speak. No. Okay.
It's better.
Okay. No. Just structurally, I query if of the utility of having the class action reform, right? In India, perhaps owing to the judicial delays and the like, we have a lot of disputes get intermediated through the government, through the executive sphere, through the political sphere, at times through the legislative sphere, although that is rare. So given that context, which is unlike the US, right? The state is much more constrained in the US. The constitutional setup is very different. Given that context, I query if, even if we have a reform for class action, what utility is going to have? How much is it going to be utilized?
Third question, and then we'll...
2 points. One is, I am not very convinced that India has a loser-pays system in the rule. The second is, I worry about general injunctive reliefs available in class action suits. I think whether a case should get injunctive relief or not should not depend on whether the suit is a class action or not. And I think especially in the case of class actions, we should not give injunctive reliefs because some members of the class may not want the injunction. But once you have given injunctions, then you are unable to get that thing. Let's say there is something wrong, but I want to forgive the mistake and just get along and get whatever I'm supposed to get from the company or from the system. When you have a general class injunction, you might have harmed me beyond any compensation amount, where I just wanted that. So I think injunctive relief should not be mixed into class action, and especially in class action, we should think about injunctive relief much more, till every member of the class really wants an injunction.
Okay, Brian, Vic.
I'll respond to some of these questions. Let me ask you guys, why is your court system so slow? What's the issue? Are there not enough judges? Not enough law clerks?
There are more than enough judges.
Okay, so
We can have a drink over that one.
Okay. All right.
You
all right.
will
Okay,
get an
so
answer to that, yeah.
I'll hold that until the last session. So, what about this question about loser pays? Do you have loser pays here in India?
No.
What do you have? Everyone pays their own fees like the American system?
But that is at the court order's cost. So
So it's discretionary.
absolutely.
It's not.
And it's bare minimum.
No, it's nominal. In reality, each side pays because
Okay.
it's not 1/50th of the real cost.
Okay, so you basically have the American rule on attorney's fees here. Okay, that's good to know.
No, we are worse than that. Almost never.
Okay, so the question about injunctions, should those be available in class actions? You know, we have this debate in the United States as well. And we have this debate under the rubric of, are there sometimes conflicts between the class members? What do you do if there's an intra-class conflict? You're not supposed to certify a class in the United States if the class members seem to be at odds over the subject matter or the relief sought in the lawsuit. And so we try to police that to some extent on the front end. The class action in the United States began with injunctions. The class action in the United States began in civil rights cases to desegregate schools and things like that. And so it has a long tradition of being used for injunctions, but I understand there can be some cases where there could be a conflict within the class and we have to protect against that. The last thing I'll note is about the suggestion of Ketam, which I think is a great alternative model, and it might be an intermediate step for a nation like India, is to involve both the government and the private bar in your mass representation devices. And so you can ask the private bar to initiate and then have the government have some kind of gatekeeping role. I'll tell you honestly, I don't like situations where governments can shut down class actions. Ketam is not that. As was noted, you can continue going on in the lawsuit. If the government doesn't join it, you can still go forward. But I don't like models where the government has to consent to a class action, because one of the reasons why the private bar is so much better than the government, in my opinion, is because the government is not independent. The government is often captured by industries. In the United States, and I gather in India as well, you have a problem with that. And so if we want to have independent enforcement of the law, I think the private bar is a much better guardian than the government.
Vic, you have any last comments? Because we'll have to leave it at that. Yeah.
Sorry, I was back there, so nobody could see my hand. I'll keep it short. I was just wondering why the public interest litigation in the epistolary jurisdiction of the Supreme Court wasn't part maybe of your talk, because that's one thing that we have seen where, like you in your financing, you said like a third party could come in and finance. One thing that we have a long tradition of, drawn from the civil kind of class action suits in the US actually, is where you can write into the Supreme Court without direct locus in the case. Just to explain it very briefly, and under Article 32, they can take suo motu cognizance. And it's been used in, say, environmental law kind of cases, MP Sharma is the big one, to actually make the polluter pay. So in epistolary jurisdiction, is that something that you think is sort of our class action?
Can we move this discussion to
Sure.
a tea break, because I'm under strict,
No worries.
very intense pressure from the organizers to move on.
Thank you all very much.
Pressure that I cannot resist. Thank you.